is the last part of the Indian Contract Act, chapter number 1, called as Remedies for Breach of Contract. So last class we looked at breach of contract, 6 various situations where a contract can be discharged or terminated. Now here we are going to look at remedies for breach of contract. So if there is a breach of contract and if the other party has suffered, what can be the damages and what can be the remedies? So when one party of the contract refuses to perform his promise, he is said to have committed a breach of contract. So in simple, what is a breach of contract is one of the party to a contract refuses to perform what he has promised. So the party who has suffered, the aggrieved party is called the party who has suffered the loss, is given full right to file a case or bring an action for his damage. So remedies for a breach means, so there is a party who has suffered a loss because one party has not fulfilled his promise. Therefore, the suffered party or the party at loss called as aggrieved party is given full right according to the law to file a case against him and claim the damages. Let's look at it. There are 5 different remedies for a breach of contract. Filing suit for damages, suit for cancellation or rescission, suit for specific performance, suit upon quantum merit, and suit for injunction. The first one, filing suit for damages. Damages refers to compensation in terms of money for the loss or injury suffered. The aim of damages is compensation and not punishment. The court will compel the party for the breach of contract to pay for the damages. So here the first remedy is that the aggrieved party, that is the party at loss, will file a case in the court of law against the other party who has not fulfilled the promise. Therefore, he has to pay the damages. Now the concept of damage is just to compensate for the loss and not to punish. So the court, once the agreed party has filed a case, will compel the party who has made a breach of contract to pay for the damages. And this damages can be in 4 types. One is ordinary damage or compensatory. Second is special damage. Third, vindictive. And fourth, nominal damage. What is ordinary damage? These are the damages arising in the usual course of things on the basis of actual loss from such breach. So if there are 2 parties entering into the contract and there is a loss suffered by the breach of contract, so based on that loss, there will be a damage that he has to pay. An example, there is a company A which is a manufacturer of furnitures. Okay, company B has ordered from company A to deliver a certain kind of furniture to them. Is that clear? But then company A, whatever the order was received, except that based on the order, company has not provided. Company has provided the wrong type or the wrong kind of furniture to company B. Is that clear? Whatever B has ordered for, that hasn't reached the company B. But what has reached company B? A wrong kind of furniture for which they didn't order or select the type of furniture, that has been reached. So on realizing that this is the wrong furniture and not suitable for what we have ordered, company B asks the company A to please take back your furniture. This is not what we have ordered for. Please give us back the right type of furniture. For which company A says that whatever you have ordered, that kind of furniture right now it's not in stock. So therefore, B has suffered a loss here. So company B is going to file a case against the company A, that is the manufacturer of furniture, and damages company A must be paying to company B. Is that clear? This is called as general damages. Second type of damage is special damage. It arises in case of special performance. These damages cannot be recovered until the special performance are brought to the knowledge of the other party. Notice that word here, knowledge of the other party. Special damages can be claimed along with general damages. So basically, special damages are an additional cost that the aggrieved party can receive from the party which has breached the contract. Let's look at the same example of the furniture. Now, if company A knew that. What did we read here? The word brought to the knowledge of the other party. That means if the company A knew that company needed the new furniture on a particular day, maybe it's a shop opening of that particular company. On that particular day, it's an important event for company B, and it is most required for the company A to deliver the right kind of furniture on time to company B. Okay, because it knew that the old furniture has been disposed of the night before. Then B can claim what kind of damages? B can claim damages for breach of contract could include all the damages awarded previously, that is awarded here, the general damages plus the special damages, that is until company B gets the new furniture, rents a new furniture. Maybe it may take another week to get for company B to get the right kind of furniture. So until then, for that week's period, company A has to pay for the damages called as what? Special damage. One, general damage is for giving the wrong kind of furniture. Second is for not providing it on the right time, and until the extension of replacing the new furniture, company A has to bear the damages called as what? Special damages. The third kind of damage is vindictive or exemplary. Exemplary. These are damages awarded to punish the wrongdoing or defaulting parties. Now there we looked at general damages for what? Just to compensate, not to punish. But here we see that vindictive or exemplary damages are to punish. The main aim or purpose is to punish the defaulting party and not only take the damages but also to punish them. For an example, dishonor of check. The smaller the check, the greater the damages. It is the bank's fault. Now in this example, now let's say company Accenture or company Tata as a supplier has supplied raw materials to company Tata, correct? And Tata company has provided a check, let's say for rupees 10,000. When the supplier goes to the bank and presents the check, okay, now if you can remember, Tata deals with, does it deals with thousands or lakhs of rupees? It deals with millions of rupees, correct? So this 10,000 rupees is not just, is nothing before them, correct? Because they deal with crores and millions of rupees. This 10,000 is not even a count for them. So when the supplier goes and presents to the banker, the banker is dishonoring the check. He says that the sufficient balance is not available in the company's account or company's current account, whereas the company has sufficient balance in the account to honor the check. Did you get my point? Supplier is presenting the check to the bank. Bank, with due to carelessness or without proper checking of the account balance, says that check cannot be honored because account does not have sufficient balance. Now whose account does not have sufficient balance? It is company Tata. Now what will the supplier do? Go file a case or go ask the company for the damages. So company can raise a case or file a case against the bank for its negligence, for not checking the balance of its account properly and honoring the check. And also, don't you think the supplier is going to, once he is going to file a case against such a big established and reputed company, the goodwill of the company is going to get affected, correct? As the statement says, the smaller the check, the greater the damages. If certain 1 crore amount is not getting honored, we understand, okay, there's not sufficient balance. But if just rupees 10,000 check is not getting encashed or honored of such a established reputed company, then it questions the company's reputation, company's capability. Is that clear? So therefore, that is why the statement says the smaller the check, the greater the damage. So here Tata company can file a case against the, of course, first thing it's going to pay the supplier. Second thing, it's going to file a case against the bank stating for what? Vindictive damages. Is that clear? So here it is going to punish the bank for its negligence. It not only lost the supplier, but also it lost its reputation. The fourth kind of damage, nominal damage. This type of damages are neither compensatory nor punishable. Nominal charges are awarded only for the namesake. So these are usually awarded if the contract price and the market price are same at the time of breach of contract and the aggrieved party has thus suffered no loss. Now for an example, if two parties have entered into a contract to buy certain goods on a certain price, that is called as contract price. Whatever you have agreed upon, both the parties mutually agreed upon a certain price, on that price the contract is based. Now, when one of the party has breached the contract or refused to buy or refused to sell on a particular day, that day the market price is also the same. So, there is not much damage the aggrieved party can suffer. But because the contract was not been able to complete or to be performed, court is going to just give a nominal charges upon the party who has breached the contract. Is that clear? I'll repeat for you. This contract, two parties entering into a contract for the sake of buying or purchasing certain goods on a certain price, which is called as contract price. On the day when one of the party, let's say the seller, has been breached the contract, that means is not fulfilling his promise, on that particular day, the price of that good in the market is called as market price. Is that clear? Let's say they have agreed on 1 kg rupees 50. On the same day, on the breach of contract, the market price is also 50. Okay. So therefore, the buyer can buy the goods in the market itself. Correct? He has not lost much amount of money. Therefore, the party has not suffered any kind of loss. But only reason that this contract or agreement was not able to perform completely, the court is going to allow certain nominal charges or nominal damages to be paid by the party who has breached the contract to the aggrieved party. Is that clear? These are the four different damages under the general damages. Second kind is suit for cancellation or rescission. When the contract is broken by one party, then the other party may treat the contract as breach and refuse to perform his part of contract. In other words, putting an end to the contract. So here what happens, A promises to sell his lorry to B for rupees 5 lakh on a certain day. So basically all things are clear between both the parties. What is the subject matter of the contract? What is the consideration? Everything is decided. On some time, the one party of the contract refuses to sell the lorry or refuses to fulfill his promise. Therefore, will the other party simply pay the price? No. The other party was willing to buy the lorry for rupees 5 lakh on a certain date, but because A backed out of the contract, B also refused to pay the price. So B has suffered the loss. Why? Because A cancelled the contract or A refused to perform his promise. Therefore, it is called a suit for cancellation or rescission. So this kind of damage is for cancelling the contract. Third, suit for special performance. This means the party in breach will actually have to carry out his duties according to the contract. In certain cases, the court may insist that the party may carry out the agreement. So, if any of the parties fail to perform the contract, the court may order them to do so. Now, let's look at this example. A decided to buy a piece of land from B. B then refuses to sell. The court can order B to perform his duty or justice under the contract and sell the land to A. Now, here suit for specific performance means instead of making the party who has breached a contract pay for the damages, instead the court will tell them to carry out his duties or promises as according to the agreement. Okay, you cannot cancel or you cannot back out of the agreement. Instead of you making court asking the party to pay for the damages, instead the court will tell the party to fulfill their performance, whatever. Here it is to sell the piece of land or to buy a piece of land, they have to fulfill that promise, whatever the parties have agreed upon. So this is for specific performance. The court asks the party to perform their duties or obligations as agreed upon the contract. Number 4, sue upon quantum merit. It means as much is earned. At times when one party of the contract is prevented from finishing his performance of the contract by the other party, he can claim the quantum merit. So he must be paid a reasonable remuneration for the part of contract he has already performed. So there are two parties entering into a contract and the contract is in process, okay, it is being executed. So one party is preventing the other from finishing his performance. Maybe he has started delivering or supplying the raw materials to the factory, okay, for the period of 1 year. So at 6 months time period, during his performance, the company is putting a or prohibiting the supplier to further continue to supply the materials to the factory. So he is preventing his performance of the contract. So this could be the remuneration of the services he has provided or the value of the work he has already done. So instead of, okay, if you do not, company does not want the supplier to give the raw materials, then the company can, for the 6 months, the supplier which he has provided the goods to company, at least for that 6 months, for whatever he has performed, the company has to pay for the supplied goods. Is that clear? So whatever, up to what point he has performed his duties or work, until that time, the company has to pay the compensation. That is called a sue upon quantum merit. As much is earned. For whatever the goods the supplier has given, that much he has earned the remuneration, correct? The price is earned. For that much time period, company has to pay. The last point, suit for injunction. An injunction is basically like a specific performance but for a negative contract. An injunction in court order restraining, that means what? Prohibiting a person from doing a particular act. So the court may grant injunction to stop a party for a contract from doing something he has promised not to do. Now basically we have heard about, while discussing about offer, what is an offer? Positive offer, negative offer. You remember those topics we discussed? What is a negative offer? It is a promise not to do something. Is that clear? It is a promise not to do something. I'm promising. Now let's say I have an agricultural land where it is a good fertile land where to grow a certain kind of crops. But there is a person who comes and makes an agreement with me telling not to cultivate certain products in that agricultural land. So is prohibiting me or stopping me from doing my duty or basically using the land for agricultural purpose. Therefore, I can sue the other person for suit of injunction. In a prohibitory injunction, the court stops the commission of an act and it will stop the continuance of the act that is unlawful. So basically it is unlawful. You cannot stop a person from doing something which is unlawful in nature. Is that clear? So therefore, the court can issue injunction order or prohibitory injunction. So if two parties are entering into the contract to do something which is unlawful, is that clear? Then the court of law can issue prohibitory injunction. That way the agreement will be terminated or the other party will have to pay for the damages. So these are the 5 different kinds of remedies for the breach of contract.